Mill Pond Manor versus Chamin Fan.
Good afternoon, Your Honor. James Martone here on behalf of Plaintiff, Mill Pond Manor.
Good afternoon, Your Honor. David Santa Croce, appearing on behalf of Mr. Fan. To my right, to his right is Stone McBeth. Stalin has left the clinic to go start a housing clinic in Detroit. Mr. McBeth is a Blissfield native, and he's joining us for the next 3 years. So you will, we're working on admission, but
So I'm supposed to say welcome or something like that?
no, I'm just giving.
Or I should say like, I like Salon better, or what do you want me to say?
Go Maryland.
Go Maryland.
I don't think you're a Maryland fan.
I get that.
Frequently on this docket, these are going to be our criminal specialists.
All right, very good. Welcome aboard, sir. All right, where are we on this case?
Just for the record, Christopher Wright is next to me on my left.
All right. Okay. All right, what are we doing here?
Your Honor, this is a difficult case. We're here because we were originally here back in December of 25. A conditional dismissal was entered in January. It's regarding Mr. Fan's occupancy at Mill Pond Manor, which is a senior residency that's subsidized by HUD. Your Honor, you may recall we've been here several times.
Mm-hmm.
We've been trying to resolve this amicably. Unfortunately, we were under the impression that after we're here on the conditional dismissal, that those terms were going to be abided by. Particularly, there was payment terms that were required. There was staying out of a gardening area that was required. There's attending gardening meetings that was required. None of that has. You'll hear today that Mill Pond Manor is being unreasonable, trying to be the Goliath in the room. That's not the case, Your Honor. What we're trying to do is just have accountability. And that's what happened on June 2nd when non-compliance was filed. Part of that affidavit identified multiple dates that did not comply with the consent order, which included gardening beyond the limited area that he was permitted to, missing the gardening meeting without an excused absence or following up afterwards, and then also an issue of late or missed rent. I will let the court know that the rent payment has been received, and part of the issue with that rent payment was that Mill Pond Manor will receive from banks, but in order to receive direct deposits from a bank, you have to register through Mill Pond Manor's portal. That did not happen, which resulted in missed payments. We had sent a demand letter in May 19th to the brother Counselor Santa Croce, informing him and Mr. Fan of these violations and requested immediate cessation. That did not occur, Your Honor. Following that letter, there still were additional attempts of gardening beyond the borders. The rent did, as I said earlier, we did receive the rent. The March and June rents were received. And there are 2 checks that are sitting in Writing's possession that we have held off on cashing, just that there's a representation to Mr. Writings that please don't cash all checks at once for fear of bouncing the checking account. And we don't want to put Mr. Fan in a situation where he doesn't have enough to cover. But if we are able to resolve that day, are able to cover those payments and the discipline not be an issue. Nonetheless, Your Honor, the whole purpose of this consent order was to have compliance occur. So what we're seeking, Your Honor, and the gravity and the weight of requested relief or judgment is not lost on us, and it's not taken lightly. We understand Mr. Fan's position. We understand that this is a residency for him. But at the end of the day, Your Honor, this is a 47-unit community that Mill Pond Manor is responsible for ensuring the safety, the welfare, and compliance with the rules and regulations.
So what are the specifics of the gardening beyond borders thing?
Your Honor, if I could direct your attention to the consent order.
Yes.
Attached as exhibit A to the consent order. And do you have a color copy or do you have a black and white copy?
You can go ahead with your statement. So I guess what?
Your Honor, I have a copy for you.
Okay.
May I approach?
And my bailiff. Okay,
Your Honor, as you'll see, there is a red triangle cordoned off just beyond the side of the building.
yes,
That was a limited space that the parties had agreed to allow Mr. Fan to garden. If you'll look around or look down this way, Mr. Fan had expanded gardening efforts all the way around to here, which was not permitted. And that is what we were asking the court back in December to address. Brother counsel and myself had agreed that Mr. Fan would stop his gardening efforts and limit it to this little border shaded in red. That has not, and part of the conditional dismissal, Your Honor, is Mr. Fan had until April 15th to remove plants, shrubs, whatever gardening implements he would prefer to keep, so that during the frost, he was unable to retrieve it, but in April, he was able to retrieve it. So April 15th was a deadline. Following that deadline, he should not be in anywhere other than that limited area, Your Honor, and that did not occur. In fact, it's on several occasions, he was located throughout down this region and not limited to here, Your Honor. The same thing goes with the gardening meeting. The residents of Mill Pond Manor are allowed to garden under strict guidelines. Every resident who does garden has to attend this gardening meeting. Notice was given, it was posted. The residents that do want to garden did appear, Mr. Fan was not. I understand it seems trivial, Your Honor, at certain points. But this is what was agreed to, and it was why we had entered into the consent order so that we have material compliance with these particular terms, because having unfettered access to this gardening area is not permitted. And the other residents are not allowed to do that. And so we can't have differing or divergent rules and regulations per each tenant here, Your Honor. And so what we're seeking is a judgment of possession, and we will want to be reasonable with the court. I'm not trying to ask the court for an immediate judgment. Our client, or my client, Mill Pond Manor, has offered reasonable assistance financially, as well as social services to help locate additional housing for Mr. Fan. Those have not been taken up upon, but we remain willing and committed to help in a reasonable transition here. For this time, Your Honor, Mill Pond Manor is not a residency or community. It's fit to serve Mr. Fan and his needs.
Thank you, Your Honor. So just for a little context, Mr. Fan is a 76-year-old former engineer who immigrated here during the Carter administration. He's a lawful resident. He is all alone. He had a stroke last April of 25. He spent 2 months in ICU and a month in rehab. Gets around with a walker. He's on a handful of heart drugs. He's also got on a handful of drugs to treat depression, suicidal ideation, memory, comprehension problems. He's also ESL. So we went without an interpreter today. We can communicate fairly well, but there is a thing there. This is HUD-subsidized. And I want to just make one thing clear. You see this long, expansive garden. That was done by Mr. Fan, reclaiming just border area between this complex. It's beautiful, and it sits right on the back of Mill Pond. That was all with permission. When the prior manager left, the new manager, Mr. Riddens, revoked that permission. So this is where the struggle ensued. The garden, it's not just a garden. The MSU extension offered in the context of settlement negotiations to maintain it in perpetuity because of the rare plants that he was able to grow in there. So this is really, it's not, I'm a vegetable garden. This isn't what it is. But they weren't interested in that. In fact, there were repeated threats by management to Mr. Fan to bulldoze. We reached a compromise. They claim that those words never happened. Obviously, there's a difference of opinion. It's immaterial. The COD, because this is HUD subsidized, requires a material violation, right? And this is stuff I learned in this court, one or more repeated. I don't have to tell the court the law, I understand that. There was an initial affidavit that came with this letter on the 19th that made these allegations. And I went down and I sat for an hour in Mr. Fan's room where I have been multiple times. There's several claims in the affidavit that you just heard from counsel, and I want to address them. The first is that he failed to pay March rent. May I approach, Your Honor? We'll start here to Mr. Allen. Counsel has put a cover page on it. This is the first, the ledger report produced 3 weeks after the affidavit of noncompliance, showing that he owes $540 for supposedly March and May rent. The second page is him paying May rent on the 2nd of March. The third page is him paying rent on the 2nd of June. The fourth page, I have it here on my phone, but Mr. Fan couldn't get it to me in time. He paid rent at the end of April and then again at the starting of May, getting rejected because he cannot understand this certification of how to get the rent under the portal. So at the time the affidavit was submitted, that rent had been paid. The affidavit is simply false on that point, and frankly, a little troubling that those representations.
Why doesn't every tenant just get a portal access?
Pardon?
They have that.
They have it. He can't, but the certification with his bank and how that can, this direct deposit, he's offered to pay cash multiple times that the former manager would accept, but not now. He's asked for the ledger repeatedly. Ultimately, I only got the ledger a few weeks after they filed this affidavit. And the ledger they produce is patently contrary to the bank record showing the receipts. Well, so he made his best efforts to pay the rent. There clearly was some technical problems. It sounds like he might owe like $30 because the rent went up in November by $8 and he didn't know, and that he didn't know in December. Mr. Martone was on my speed dial during that last case. We were talking a lot. We never heard anything about that. So I think the rent is a canard.
Well, my understanding is that's moot.
It feels like it, but it's got to. I'm getting to the point. It's got to be a repeated, intentional, willful violation. This clearly wasn't. So now we turn to the garden, right? It sounds like the court has passed the rent and onto the garden. Is that a fair reading?
Well, I don't understand why the rent is. I mean, if it's been rectified, it's been rectified.
Well, it just was a ground for them claiming a violation. I thought I had.
No, I understand.
All
I
right.
understand that, but.
So as to the garden, there is a video on May 12th where he walked into the larger part of the garden. There is runoff from a couple of swales to get a bucket of water to feed a rare tree in his section. That's all it was. There hasn't been a documented intrusion into that area since. In fact, counsel sent me videos from the 31st that say, well, here he is out of the garden, and they clearly are him in it. That's why I think we're not seeing them on the record today. So I went down there. He's complied. He made that one trip out. He shouldn't have. He believed that he had till May 15th. Again, this is comprehension, not April 15th. He hasn't been there since, and there's no evidence it's been there since. The garden meeting, he went past at 45 minutes before. He went back at 10 minutes of. There was no one in there. There hasn't been a garden meeting since. He's willing to go. In fact, he's willing to give up the garden. He doesn't have anywhere else to go, right? There are letter violations that counsel had the good grace on the May 19th to say, we're not worried about it, but there hasn't been one since. They claim there is, but there's no evidence. None of them repeated, all of them minor, none of them to our mind material, let alone willful. He's largely performed for 6 months, and the balance of the hardships here, they have offered him, I had not heard before just now that they offered to find him, help him find additional housing. That might be something that we would consider. but he's got nowhere to go. He's old and frail, and he's largely performed for 6 months. I'm not sure what that unauthorized trip to the garden really harmed them in any way. He thought he was within the rights. He wasn't. We would ask that he be allowed to stay because he has nowhere to go, and he's fully gets $1,000 a month disability, or I think it's Social Security now because of his age. And he pays his rent. It's $250. I don't know where. I don't know how to help him, given the current housing situation and his medical condition. So for those reasons, you would ask that he remain.
Your Honor, I would just submit to the court that there has been evidence of Mr. Fan being in the restricted area of the garden on multiple occasions. In fact, Tasha.
Well, hold it, gentlemen. It just seems to me he's willing to give up the garden.
Yeah.
I understand, Your Honor, but this has been a repeated conduct. We were here on a failed payment a year and a half ago, and then that was.
I spend all day Friday dealing with failed payments. And I mean, the money aspect, quite frankly, certainly if it's been rectified, is of little consequence to me, and I would not issue any negative or judgment based upon that. I mean, he's rectified it. People these days are just spending all their time trying to rectify their rental obligations. It seems to me that it's the garden or there's some other issue, but somebody may be saying, if he's willing to give up the garden, then I don't have an issue, do I?
Yes, insofar as, Your Honor, that he agreed to give up gardening on those particular areas previously. And
Yeah, but he's willing to give up the whole thing. So it's not even going to be an issue of, are you gardening? He can't be gardening.
Your Honor, I fear that we're going to be right back in here because he's going to be gardening again.
And when you grace my doors, I'll say welcome.
But I want to see me that many times, Your Honor.
Again, this offer has been made multiple times, and we're willing to live with that compromise.
I mean, I guess I don't understand what plaintiff's hesitation in that is.
Your Honor, this has been an ongoing. There's been multiple issues with Mr. Fan's tenancy. When we were here in December and agreed to enter into the consent judgment, there were also other issues about health code violations or keeping his place tidy, having the property made free of any debris or refuse or his gardening tools. There was a physical altercation a couple years ago between Mr. Fan and Mr. Riddens. And there's been a pattern of issues that has escalated to this point. We had the consent judgment, which said he will not do these matters. He agreed.
But he didn't have these issues till he got here.
I can't speak to because I don't know who the prior manager was, Your Honor.
But it sounds to me like he didn't have problems with the prior manager.
Your Honor, that's not my understanding.
There hasn't been a case until these, Your Honor. There was a non-payment case that Miss Kim from Legal Services had that was over non-payment that was dismissed because payment had been made. I mean, the only issue with payment is technological and the new limitations on the way payment is accepted and the repeated refusal to provide Mr. Fan with a ledger. And as to these other things, Your Honor, none of them were pled in the complaint. None of them were part of these things. We're going back to ancient history. Like, I just don't think it's proper.
Well, and I don't want to go back there either. I'm just trying to figure out if the crux of the issues, there are really seems to be two issues. One is the rent. That's been resolved. The other issue is the garden. And he says, I'll give it up. I just won't do it. Why that isn't a reasonable I guess, resolution outside of eviction.
Your Honor, and my only response would be, because that was what was agreed to 6 months ago, that he wouldn't garden in this area. So what's stopping him from start gardening again?
Sounds like I'm dealing with the damn straight of her move. What do you mean, what was agreed to be? I get it, but that doesn't mean that the court has to take the most harsh remedy in regard to rectifying what somebody sees as a breach.
And Your Honor, that's why we're asking for a reasonable transition period of not kicking them out tomorrow, but we'll
But kicking him out nonetheless.
helping him.
Nonetheless, kicking him out. Like, I mean, say what it is. I mean, that's what it is. You want to evict him, but we want to do it nicely and in a gentle way. When he's willing to do that thing that won't cause him to be evicted and moved at all.
I understand, Your Honor. As if we have a judgment that same terms, if he doesn't materially comply with the lease, we're not having to go through this dance over it. I mean, this is our concern of having a tenant that complies with the lease, just like every other tenant in
Are
that.
these elderly individuals?
Yes,
All of them. There are 49 in the complex.
You're telling me that every one of those elderly individuals complies with every rule?
Your Honor, for the most part, yes.
No, because that's the problem. If for the most part, that's it, or if they do it. I mean,
But if I can rephrase it, Your Honor, I would not be candid with the court if I said there hasn't been Mr. Writings having sit-down discussions with certain tenants over occupancy of their property. However, nothing has escalated to the point.
is there a social worker present?
Your Honor, there is not on site.
Why isn't there? I can't understand these places that have senior citizens that don't have a social worker available to deal with.
So, Your Honor, there was someone from so this is a national religiously oriented, environmentally, according to their mission statement, oriented organization out in California. Someone from that organization, a social worker, called Mr. Fan last week, didn't offer any help, but at least offered to hear him out about his difficulties. I think emotionally that helped him feel a lot better. This is called it was the RHF Director of Social Services. It sounds like she's based out of the West Coast, but has been no social services available, or we haven't heard about any social services from the company until last week when he got this call out of it.
Your Honor, respectfully, that's not an entirely accurate statement. They did offer services and to assist with alternate housing. It was declined.
When was that?
Whenever Mr. Fan spoke with. them.
Right, so that was the first contact a week ago. 9 or 10 months into the litigation.
Counsel, you believe that his violation of this was intentional?
I do, Your Honor.
All right, here's what we're gonna do. You guys want to do that? You're gonna have to put up or shut up. I need a hearing date on a Tuesday. We'll just go through we'll just go through a hearing. And then I'll make my finding.
July 21st.
July 21st?
Yes, sir.
What time, 9?
9
July 21st, 2026, 9 AM. Bring all your witnesses, bring all your evidence, and let's just do it.
So, Your Honor,
Yes, sir.
he has a hearing where here? Oh. I thought that's Steve. No, we're good. All right, so I just want to I thought I had one in front of, no, I can 100% do that. We will be here at 9.
It works on our side here. 21st? Yeah, at 9 AM.
All right, very good.
We are amenable to modifying it along the court's direction between now and then if you're in.
I appreciate it.
Thank you, Your Honor.
All right.
Right.
All right. Thank you, Your Honor.
You.
Thank you, Judge.